Good afternoon, everyone, and welcome to our second instalment of the Women in Planning Lunch Bites webinar today. My name is Mandy Gill and I am the Chair of Women in Planning West Midlands Committee. Today's session is led by Nicola Gooch, who is a planning partner at Irwin Mitchell Solicitors. Nicola will talk to you about the recent changes to the youth classes order to create Class E. For those of you that don't know Nicola specialises in mixed-use regeneration schemes for a wide variety of private sector clients, including house builders, land promoters, investment funds and care home providers. She advises on a range of planning issues with a particular interest in community infrastructure levy. Nicola is ranked alongside the Southern Region Planning Team, which is Tier 1 rated in both Chambers and Legal 500. She was recently recognised as a leading individual by Legal 500. This session will last 30 minutes with a 15-minute Q&A opportunity at the end. As usual, if you have any questions, please do note them in the chat function, and if we have time at the end, I will pick these up. This webinar is being recorded and will be uploaded to the Women in Planning YouTube channel. I will now hand over to Nicola.
Afternoon, everyone. Apologies, you might have to bear with me a little bit. I returned from maternity leave all of about an hour ago. This is the very first thing I'm doing on my return, so please be kind. I have had a practice run, but the audience was a 3-year-old who told me off for interrupting Peppa Pig. So she might not have been quite as receptive as I'm hoping you will all be. In the next half an hour, can we move to the next slide, please, Lisa? We are going to cover what Class E is, why it was such a radical introduction and change to our planning system, some limitations and things that you need to be aware of when dealing with Class E properties, the Class MA permitted development right, which was then subsequently introduced, which allows changes from Class E to residential, the reaction to that permitted development right, which primarily relates to Article 4 directions, and then a couple of upcoming cases that we may not need to deal with. It's going to be quite a packed half hour. If I'm going too fast, then please slow down in the Q&A, and I will do so. But we have quite a lot to cover, so we should probably get started. What is Class E? So in September 2020, the government undertook possibly one of the most radical changes to our planning system that we've seen in recent years. They moved a whole load of very familiar uses which had been in separate classes in the use classes order, including a number of retail uses, A1, A2, A3 shops, cafes and restaurants, and business uses into a single use class, which is now Class E. Class E comprises, as you can see on the screen, retail, restaurants and cafes, both types of office use, so those which you would originally have found on a standard high street, hairdressers, estate agents and traditional offices, indoor sport, recreation and fitness, medical and health services, creches, nurseries and day centres, and research and some light industrial into a single use class. The reason this is so radical, and the reason why Dominic Cummings in a now infamous blog post referred to it as the largest radical change that they introduced by stealth, is that moving between uses within the same use class no longer constitutes development. It is completely outside of the control of the planning system for the most part. What this means is that you no longer need a change of use application to a local authority to move between any of these uses. At the same time as doing this, they also created classes F1 and F2. F1 is learning and non-residential institutions, schools, etc. And F2 is local community uses, which is primarily corner shops. And they do not have any permitted development rights associated with them, and those use classes still require changes of use. Now, there are a number of reasons why we need to pay attention to this. The first is it rides a complete coach and horses through the relevant use sections for retail planning and high streets in the National Planning Policy Framework. Those sections of the NPPF have not changed despite Class E coming into effect. So we now have a system whereby local authorities, when looking at new applications for town centre uses, still have to apply a sequential test, still have to go for town centre then edge of centre before looking at out of centre, and still need to carry out impact assessments on town centre uses, even though as soon as the new floor space is granted, it can then, once it's been open and occupied, change use without further involvement from the planning authority. The other coach and horses moment when it comes to Class E relates to the community infrastructure levy, which, as Mandy mentioned earlier, is a little bit of a special interest project of mine. Class E was introduced many years after SILFAS came into effect in 2010. And as a result, a very large number of local authorities have adopted charging schedules which refer to the old use classes orders. And in particular, many of them levy still on some Class E uses, but not others. The big ones primarily being offices in London and large scale retail. If you are dealing with a application where you specify what that use is going to be in a Class E application, it's fairly straightforward because in November 2020 they updated the SIL regs so that you basically read across the old, the new part of Class E, whether it's Class EA to Class EG, into the previous charging schedule. So if you've said that it's going to be Class EA, which is retail, and there is a retail charge in the council's charging schedule, then that's easy enough, it reads across. Where you're just applying for straightforward open Class E uses, there is no guidance as to how local authorities are supposed to treat that from SIL charging perspective. Now, a large number of authorities that I've been dealing with have tended to use the same approach as they do with flexible workspace, which is unless that you tell them but prior to commencement who or what the use of that space is going to be, they tend to assume that if it is capable of being a SIL charging use, then that's the use that they'll apply to it, which can cause viability issues. It's a tricky one, so it's something that's definitely worth thinking about when you've got mixed use development or commercial space. Can we move to the next slide, please? Now, as I said just a moment ago, excuse me, moving uses within Class E does not constitute development and therefore does not require any changes of use or involvement of the local planning authority. However, there are limits to that. And this next we're going to talk about some of those limitations. So, before you can move use under Class E to another part of the class, so before you can go from retail to a restaurant, for example, you must have in your unit an existing lawful established use. So if you've got a brand new new build development which has retail space in it, then that retail use has to have commenced before you can change it. So you can't switch the use of a vacant unit. The use has to have been established before you can switch uses. Otherwise, it's not a change of use per se because there was no previous use. And that existing use really should be a lawful one. So Class E does not help you very much if you don't actually have an established use of the unit that you're looking at. It's also capable of being restricted by condition. Now, you will have all previously seen the old conditions that you used to get primarily on large supermarkets, where they would, or DIY stores, where they would limit the types of goods that could be sold in it or limit the types of uses so that you could have A1 retail on a certain amount of floor space, these types of conditions. Whilst changing the use of a unit under Class E falls outside of the planning system, that will not help you if you are breaching a condition when you're doing so, because you can still have the breach of condition enforced against you. So you need to make sure that you check the conditions on your planning permission to make sure there aren't any restrictions in there and you are actually able to easily and freely change the use. Similarly, Section 106 agreements, if there is a restriction on the types of uses that you can use your unit for in the Section 106 agreement, then that is still enforceable against you, and you would need to get that Section 106 agreement varied before you change the use, regardless of the use classes order. Another really obvious one is, but I have seen it catch people out, is that the change of use between different parts of the use class only relates to the change of use. It doesn't give you any right to do any external works to the building. If those would constitute planning in and of their own right, then you are still going to need consent for them. And one last point, because Mandy did introduce me, and if I don't mention this, then she will yell at me. Believe it or not, it would happen. Always check the lease restrictions and user clauses in the commercial leases relating to the property, if you are a tenant, to make sure that what you're proposing to do with it does not breach the underlying commercial property lease. Because you will get in trouble with your landlord, regardless of whether you need planning for it or not, or whether or not it ties into use classes. And it can cause real issues if you switch to a use in breach of your tenancy agreement. Can we move to the next slide, please, Lisa? So last year, actually no, earlier this year, sorry, in August of this year, we then had the introduction of Class MA of the General Permitted Development Order, which is the ability to go from a Class E use to residential under permitted development. Now, I could have spent the entire half an hour just talking about this PD right, but I'm not going to. So this will be a slightly high level discussion. If you do have any questions, do raise them and I will deal with them at the end. I see we've already got a couple of questions about this particular part of the talk in a moment. So what the government did was amalgamate a very large number of separate PD rights in the same way that they amalgamated the use classes. And this new Class MA is more generous than some of the rights it replaced and less generous than others. So it is now under permitted development right possible to go from Class E to Resi, and provided that you hit the certain requirements and you can get through the prior approvals. Now, I'm not going to go through all of the restrictions. The key ones to be aware of is Class MA applies in the conservation area, whereas a lot of the previous rights didn't. There is a 3-month vacancy requirement, so the unit in question has to have been vacant for 3 months immediately prior to the date of the prior approval application. It also, and these two run slightly in conflict, but there isn't the same timing issue, a requirement that it's been in 2 years continuous use of a Class E use or one of the former uses in Class A. So, and this can be any of them. So your unit must have been vacant for the last 3 months, but also have had 2 years continuous use as either a shop or a nursery or a healthcare unit or a restaurant or a cafe or something that falls within Class E. If you can get through those two, then it's possibly able to be converted, subject to the maximum floor space restriction, which is a cumulative restriction of up to 1,500 square meters. And it's not in one of the restricted areas, such are the same as they were before primarily. So it's available in conservation area, but not in an area where there was previously bomb disposals or military use, those types of things. You also have restrictions over certain agricultural tenancies. So if there's an agricultural tenancy on there, you can't convert, and other things which are standard to various parts of the order. They're not new for this one, so I'm not going to spend too much time upon them. Now, if you hit all of those conditions, then you get to the wonderful prior approvals. Now, some of these are standard and some of these are new. So transport and safe access with a specific requirement for safe access to the unit as well as highways. That's relatively new. We've got prior approvals for contamination, flooding and noise. They're not, they were there before. Natural light for all units in the building, sufficient levels of natural light. That is now standard, it was introduced last year. The ones which are perhaps slightly more novel are if you are in a conservation area, and only if you are in a conservation area, you'll have a prior approval which allows the local authority to assess the impact of the loss of the ground floor units of your conversion into residential. And this is primarily aimed at protecting pretty high streets and conservation areas. You don't have that ability for retail units anywhere else, or anywhere else that's conservation area specific. The other two, which are somewhat niche, is if you are in an area which is deemed to be an important area for waste processing or heavy industry for a local authority, then the impact of the introduction of residential use into that area. But interestingly, that's impact on the occupiers of the residential units, not on the wider area itself, which might be why we're seeing quite so many Article 4s come forward, but I'll come on to that in a moment. Sorry. And finally, there is a prior approval if you are converting a nursery or a local health centre, which allows local authorities to assess the impact of the loss of that particular nursery or health service on the provision of those types of services in the area. Now, that one was introduced following quite a lot of lobbying during the consultation on this PD right. It was not originally there, which I personally, because I lobbied for this for myself, found quite offensive, because nurseries and health centres are things which are funded through Section 106 agreements and through SIL on new build developments. And quite often PD schemes don't attract Section 106 obligations and may not be making SIL payments, which means that you could be paying for a service through a new build development, which is then immediately lost through PD without it being replaced. So I'm actually quite glad to see that particular prior approval there, not least as a mother of two young children who are both in day nurseries, and I know how difficult it can be to find a good one. But nevertheless, one of the most interesting things about this is it's quite an extensive prior approvals list. And you might think that because there is now so much for local authorities to deal with on prior approval, and some of this, particularly contamination, flooding, transport, requires consultation with stakeholders, such as the Highways Agency or the Environment Agency, that that central government might have removed the 56-day timescale threshold for dealing with prior approvals. They haven't. So the 56-day time limit, which we all know now can be extended, still applies to Class MA conversions, which is not very long. So we still have the situation where the local authorities have 56 days from the date that the prior approval is properly received to consider and respond to the application. And if they don't, or you don't agree to the deadline being extended, then the prior approval can be granted by default, because you are allowed to start the conversion if you, once that 56-day period expires if you haven't had a response. That's still in paragraph W of part 3 of the GDPR. Can we move to the next slide, please? So we've had two very major radical changes in quite a short period of time to our planning system. How have local authorities responded? Well, there has been pushback, and this pushback has taken two forms. One is the introduction of Article 4 directions, which I'm going to talk about now, and then I will very briefly talk about the litigation, which is also happening. Now, the eagle-eyed amongst you will notice that I have reused this picture from my blog. And this picture was photoshopped in the tenure of our previous Secretary of State. But I did not have the time or the energy to switch it to Gove. I think we have a problem. It is, so it remains generic. I think we have a problem. This is my youngest daughter, by the way, looking very businesslike on her toy mobile phone. According to research by Property Week, just under half of all London boroughs are planning to introduce Article 4 directions against parts of or all of, depending on the local authority, the new Class MA PD right. Now, some of these are intended to be replacements for the Article 4 directions they put in place for the office to residential conversions. And I should have mentioned this on the last slide. The office to residential conversions under Class MA, if there's an existing Article 4 direction preventing office to resi conversions, you're going to have to wait a year before you can do it, because there is a grace period that extends the effect of those existing Article 4 directions until next year. So a lot of local authorities are lining up replacements for those which apply to the new right MA to kick in when the previous ones expire next summer. However, some are going a lot broader than that and are trying to exclude the entirety of MA from the entirety of their borough. This is not just happening in London. I know that Crawley, my local council, has an Article 4 direction going through to protect their major business district, and other authorities are looking at their main high streets and other sensitive areas for Article 4 directions. Harlow has one going through at the moment as well. The government did anticipate that this might happen. So, a few children in nursery, of course, I have very quickly acquired a cold. So they changed the wording in the National Planning Policy Framework and the associated guidance around Article 4 directions at about the same time that they brought Class MA in. And what you have on the screen is the new wording of paragraph 53 of the NPPF, which says when Article 4 directions are appropriate. When it relates to changes from non-residential to resi, so this is specifically Class MA and a couple of additionals, Article 4s should only be used where it is necessary to avoid wholly unacceptable adverse impacts, which could include the loss of the essential core of a primary shopping area, which would seriously undermine its vitality and viability, but would be unlikely to extend to the whole of the town centre. And in all cases be based on robust evidence and applied to the smallest geographical area possible. That is a much higher hurdle than the previous wording. And the previous wording is actually still on the screen, it's just in the second subparagraph now. In all other cases, be limited to situations where an Article 4 direction is necessary to protect local amenity or the well-being of the area. That's what the test used to be. Which means that it should be significantly harder to get Article 4 directions against Class MA. Which, if you think about it, makes logical sense, because why would the government make such a radical change if local authorities could then just use Article 4 to circumvent it? Despite this new wording, we have a very large number of Article 4 directions currently being processed. Most of them are being processed using the 1-year waiting procedure, which means that they'll take effect a year after they're made. And with these, it avoids compensation requirements, which is why most people are doing it. There is an ability for the Secretary of State to intervene and either amend or refuse the order later on down the line. And we simply do not know how our new Secretary of State is going to respond. So we are currently waiting to see how our new Secretary of State, how Mr. Gove, is going to respond to, for example, Richmond's, is it Richmond? I think it's Richmond. There's a borough in London which is looking to seek to exempt the entirety of the borough from MA use, this particular permitted development right through an Article 4 direction which applies to the whole Borough of London. We will have to wait and see whether or not that's something which our new Secretary of State would intervene in. If Jenrick was still our Secretary of State, considering he championed this particular PD right, I would be pretty confident that we would see some state intervention in these Article 4 directions in the same way that we did when the Office to Residential Permitted Development right was introduced. However, Michael Gove seems to be taking a very different approach to planning reform, so I'm not entirely sure how he is going to deal with it. I guess we'll have to wait and see. This then leads us on to, we'll move to the next slide, the second stage of pushback. Upcoming litigation. There were, when I started preparing this talk and I suggested it, 2 cases going through the High Courts which could potentially undo all of this, all of the reforms that we've just seen. The first was the Rights Community Action case, which is on its way to the Court of Appeal, and in fact was heard in the Court of Appeal in October. And as of this morning, when I checked, we haven't had the judgment yet. Now, if that has changed since first thing this morning, I have incredibly bad luck, and I have not seen the judgment or read it. But as far as I'm aware, we're still waiting the outcome. The second case, which was an Islington challenge, was against the introduction of Class MA. Now, I have it on very, very good authority that that challenge was withdrawn before it went to a hearing. So that's no longer proceeding. I do not know why, and I would love to find out, but I suspect I'm not going to. Which means that the only route on litigation now is the Rights Community Action challenge in the Court of Appeal. Now, this challenge is all about whether or not the introduction of Class E and 2 permitted development right changes which came in at the same time as Class E, which was the ability to extend upwards residential and commercial buildings by 1 or 2 stories, required a strategic environmental assessment under EU law, because they are plans or programmes which set the framework for future development consents. Now, the first instance judgment held that they weren't, and a strategic environmental assessment was not required. However, they got the right to appeal solely on that ground, and the case was heard in October. So we should find out before Christmas what the outcome of that particular piece of litigation is. Now, if they win, it will be interesting to see what happens, because it could mean that the decision to introduce the use classes order changes is quashed. If it is quashed, then the permitted development rights changes would also fall with it, because there is no use class E to fall from anymore. And we could be into a very, very uncertain period while we wait to see whether or not they are consulted on and reintroduced or not. It will be interesting to see what the Court of Appeal makes of this, because if Rights Community Action win, there will be a period of very intense uncertainty and minor chaos in the planning system once we all figure out where to go next. It is always possible that there could be an unlawfulness declaration, but the change is not, and the introductions aren't quashed immediately, but we would have to wait and see. Right, that is exactly half an hour, and that is exactly the length of the talk that I had planned. So now I get to see what terrifying questions you will ask me. And we have 4. So, first question that I've got here is, what is your opinion on the definitions for development not permitted under Class MA, MA1, in respect of C, the floor space restriction? Is the way this is worded in the order a single opportunity up to 1,500 square metres into any one building, or does it in fact permit successive applications within a larger building, so long as each does not exceed 1,000 square metres? It seems to be open for interpretation. So my answer to this is yes, it is open to interpretation. I suspect we won't know for certain until we get a test case on it. It is the cumulative floor space, which would suggest that it could include previously converted. However, it's also a building, which means all or part of a building. My gut is that it probably the cumulative probably means that it is actually a lot more restrictive, and it's 1,500 square meters per building in aggregate, because the intention, if you go back to the consultation and the consultation responses, was to prevent very, very large buildings being switched into residential. They were particularly concerned about anchor stores and very large commercial buildings in business improvement districts. So it is open to interpretation. It could go either way, and we probably won't know for certain until we get a test case on it. But I suspect that it is probably intended to be cumulative and therefore more restrictive. Question from Mark. As moving within Class E doesn't constitute development, is it lawful for LPAs to try to restrict use within Class E to a specific part of E through planning conditions? Yes, I strongly suspect it is, because they did this before. So A1 retail has been limited by condition for a long period of time. So you'd see food stores with open, so a food store with an open A1 consent or a B&Q with an open A1 consent was far more valuable than one which had a use class restriction on it, which prevented sale of food or convenience goods on it. And that's happened for years and years and years. I don't really see this as being any different, in the same way that you get subdivisions of offices on conditions. I also think that it's probably a lot more likely to happen now because of the interplay with SIL. Because unless that condition is there and you're applying to remove it, and then there'll be very big arguments about whether that application to remove it is still chargeable in and of itself, depends on how you do it. You could go for a Class E space for a non-SIL chargeable use, and then immediately switch it to a SIL chargeable use within a week of it opening, and the local authorities will lose out on quite a lot of money. I have heard people talking about that as a concern, and I would expect that, considering some of the decisions that local authorities are making around SIL at the moment, that will actually happen. You will get a lot more restrictions just to protect their ability to obtain SIL receipts in the future. Claire, does the continuous use for Class MA require a single use, i.e. retail, or can there be a change between uses in the Class E over the 2 years? It actually says one or more of the uses in Schedule 1 in the actual text. I just summarised it quite shortly to get it all onto one slide. So it can switch between the uses, or at least my reading of it is that it can switch between the uses. But what it can't do is go out of Class E and then back in again. So you can't go from retail restaurant, which is there, to drinking establishment, which is not, and then back in, because you'll lose the time period when it was a drinking establishment, for example. So it would have to be within the Class E uses. Oh, wow. Sorry, the next question I'm going to read says it's from the entirety of Pegasus Group in London. Hello, everyone. There are quite a lot of you. That's terrifying. We've already covered this one, I think. With respect to the 1,500 square metre threshold, could you make multiple prior approval apps for a single building? I suspect the answer to that is going to be no, because it does say cumulative floor space in there. But again, it is open to interpretation, and it may very well be that time and litigation proved me wrong on that one. Is prior approval for changes of use under Class E? Okay, so if you're changing uses within Class E, there is no prior approval mechanism. So you can go from one Class E use to another Class E use without engaging the prior approval system at all. You don't need any kind of application at all. Because it's now within the same use class and it's not part of the planning system, you don't need consent for it. You only need the prior approvals for when you're going to residential, because that's being carried out as a change under the general permitted development order rather than a change within the same use class. The reason that A1 to A3 previously needed a prior approval or a check system is because the change from A1 to A3 and back again was actually permitted by the general permitted development order, not because they were part of the same use class. I hope that's clear. Listening to myself say it back, it sounded as clear as mud. But that's where the distinction was. There were PD rights which allowed you to go from A1 to A3 and back again under permitted development. If you're moving between subparts of Class E, then because it's all within the same use class, it's not development at all, as opposed to being permitted development under the GDPR. Okay. I have a question with somebody agreeing to me that it's cumulative floors based on 1,500 square meters, as that's what's said in the explanatory memorandum. Thank you for that comment. I'm glad to see that's not just my view. Any update on how long a unit is expected to be occupied in their lawful use in practice before the new permitted development rights awarded for the new Class E would apply? So if you're going for PD rights, then the only restrictions are those which are in the PD right itself, which is 2 years prior usage before you can switch. But that's prior use. It doesn't necessarily, it's continuous, a period of 2 years continuous use before you can switch it to residential, and the 3-month vacancy period, which realistically means 2 years and 3 months if you're going to be full on belt and braces about it. If you're asking how long it needs to be occupied before you can switch from one part of Class E to another part of Class E, there is no guidance on that. It does not have to be very long at all. You just need to show that the use was there and active in trading. And then provided you're not restricted by condition or something else, then you can just switch it. I've seen it work perfectly with it only being open for a month or a couple of weeks. An A1 unit yet to be built, does it benefit from Class E? If it hasn't been built yet, then no, because if it hasn't been built, then it doesn't have a use yet. It needs to have actually been built and then go in and use it and then change the use. It's the existing lawful use issue if you haven't actually built the unit yet. The trick there, if you haven't actually used it, is to probably go in and vary the permission to allow something else if you can. And finally, grade 2 list of 3-storey building in a conservation area. Converting the top 2 floors. So I'm going to read this one in full twice because it's got quite a lot of component parts to it. A grade 2 listed 3-storey building in a conservation area. If we were to convert the top 2 floors to one residential unit, ground floor remain as a commercial shop. Building has been empty for over 6 months but was previously used for over 2 years. Change of shop front to create new door, entrance to hall and stairwell. Does this require planning change of use? You will need a prior approval for the top 2 floors if you're doing it under Class E. And I'm assuming the whole thing was a shop originally. So the top 2 floors you could do under PD in a conservation area, but you would need to go through the prior approval procedure. The ground floor unit stay the same. You would need planning permission to carry out the physical changes, both to the external and to create the new entrance. And you would also need unlisted building consent to make those changes, and actually any internal changes as well which affect the character of the building. Now, where this may get interesting is how the availability of the PD for the change of use interplays with your planning application for the physical works. Because the change of use is deemed acceptable under the PD, and that would be a fallback and it would be a relevant planning consideration, but you can't physically make those changes without having the other one. Now, this is relatively new, and I think it's a very good valid fallback, but you might find some complications around how those two interplay together. Please can you explain what is meant by lawful existing use has commenced, i.e. what if retail unit is built but is not occupied or selling goods? Okay, so if you have a constructed building which has not been occupied, then arguably that building, even though it has a lawful planning use, hasn't been used yet, so the use hasn't commenced. You would need to have had someone in there selling something out of it to establish and commence the use before you can change it. Now, it might not actually need to be for very long, but you would need to had somebody in there and trading before you can change. That said, getting a variation to the planning condition, providing that it's not in the description of development, because then it gets harder, to allow the change should be very easy, bearing in mind that it's considered acceptable under the GDPO as soon as you started trading it, if that makes sense. If you don't want to put somebody in, you need to change it beforehand, or you occupy, start trading, and then move it. Pegasus Group London again. If rights community action succeeds in the Court of Appeal, what happens to planning permissions approved for Class E uses? I don't really know. They will still stay valid because Class E existed when they were granted, but it's going to get very complicated. I know that many applications at the moment are specifying which part of Class E, in which case it would revert back to the previous uses, I'd imagine. But the honest answer is I don't know. We will have to unpick that one if rights community action succeed. Do you need to market the property in a 3-month vacancy period? Not under the general permitted development right requirements for Class E, for Class MA. That is not a prior approval requirement. Now, because it's not a prior approval requirement and local authorities can only take into account what's specified in the prior approval, the answer is it's not legally relevant whether it's been marketed or not, because what you can take into account under permitted development schemes is very tightly worded, and you can only take into account the NPPF insofar as it directly relates to a matter for a prior approval. And the prior approval is a 3-month vacancy period, not a 3-month marketing period. However, I would expect this is one of the areas of the new PD right which I am expecting to see litigation over at some point, because I would not be surprised if local authorities try to push for marketing during the 3-month vacancy period, even though it's not a requirement of the prior approval itself. If you are changing a building under Class E, does this apply to the external areas of the site as well? Depends on your site. So if you've got a site which is in a single use, and that includes the external areas that you switch, then the whole thing would realistically switch together. If you've got a site which has multiple uses in it and you're not moving all of them, and it could get a bit complicated. So maybe, maybe not is the answer to that one. Okay, and this is where we get into the nuances of new things. Okay. I've just published something before I read it out. So this is a question about whether or not a new unit would benefit from Class E before it was used. So if it was approved as A1, then surely it would be Class E. Yes, it would. But if it was approved as A1, it's a Class E building. But to move within Class E, it needs to have a use. So whether you could have something which had been granted previously as an A1 retail unit, which is a subdivision of Class E, and then hadn't been occupied or changed, and you wanted to open it straight into another Class E use, that could put you in breach of the original planning, depending on what the plans, etc. show. So if you've shown it as a retail unit, there aren't any other conditions, etc., and you've got a condition on there to build and open in accordance with the approved plans, then the safest thing to do would be to open it as a retail unit and then change the use, because that change of use is expressly not a permitted development once, sorry, not development because it falls under Class E, moving within a use class. But you will have built it out and operated it initially in accordance with the approved plans as planning condition. So it's a condition you want. It's not that it's not Class E, it's just that if you're changing within Class E, you're changing uses within a use class, then it helps if you've got the original established use within Class E to move to and from. It may very well be that it turns out that you don't later on, but at the moment, the safest thing to do is establish the use first, because then there is no doubt and there is no argument about whether or not you're in accordance with the approved plan which showed it as retail, or whether or not you are breaching your original planning permission because you never opened it as retail. I am more than happy to be proved wrong on that point, and I would love to be proved wrong on that point. I just think that at the moment it's by far the safest thing to do. Right. That's our 45 minutes. And I think I've run out of questions. Any more? In which case, thank you everyone for sticking with me for that long. I hope you find it useful and slightly more impressed with it than my daughter was when she had the practice session. At least nobody has typed in telling me that I'm interrupting Peppa Pig and to be quiet, so I will take that as a win.
Thank you, Nicola, for a really informative legal update. I appreciate it's very technical, and the webinar will be loaded onto the Women in Planning YouTube channel by the end of the week, if you'd like to refer to the slides again. Our next Women in Planning Lunch Bites webinar will be held on Monday, the 6th of December 2021, and our guest speaker will be Sophia Gibson, an Associate Director and Social Value Lead at CBRE. Tickets will go live 2 weeks before the event. Thank you everyone for joining us today.